Welcome to Vampire Divorce with attorney Clarke Young.
Welcome back to Vampire Divorce with attorney Clarke Young. Clarke is a seasoned family law attorney, consultant, and expert witness who helps courts and families navigate the realities of high-conflict custody cases. I'm Lisa Mosby, your host, and today we're talking about why co-parenting is a myth in borderline divorces. Welcome, Clarke. Thank you so much for being with me today.
Thank you for having me.
Clarke, courts often start custody cases with the assumption that co-parenting is the goal. Why does that assumption break down immediately in cases involving borderline personality disorder?
The idea that co-parenting is the goal and is based upon certain false assumptions for borderline cases. Uh, by definition, borderlines are what we call the anti-parents. I mean, they're the ones who cannot co-parent or parallel parent. They're the ones who cannot compromise. They're the ones who cannot. Uh, Everything has to be their way or the highway. And when you understand that, and most courts don't, then you're starting from a false premise. And that's why so many courts spend so much time uh, assuming it's a bilateral conflict of some kind. And at some point, the people will calm down and become more rational, and then they'll start agreeing on things, and things will all work out in the end. But it's the opposite. The longer these cases go on, the worse they get, the more conflicted they get, the more damage is being done.
And then, Clarke, in your experience, what does the court usually mean by co-parenting, and why does that definition fail to account for how borderline parents actually operate?
But when you're talking about co-parenting or parallel parenting, you're talking about you're assuming that you're dealing with two normal range people and that they have a certain level of communication skills. Uh, you're assuming that they're rational human beings. You're assuming that they are sane and that they actually want to co-parent and that they have their children's interests first and foremost in their minds. That's just not the case with borderlines. I mean, that's why you're dealing with. I mean, it sounds very terrible to say, but it's just a fact of life. You're dealing with people who aren't dealing with reality. You're dealing with people who cannot put their children's needs ahead of their own needs. You're talking about people who base all the relationships, as I've frequently said, on power, control, deceit, manipulation. So their whole goal in life is to subjugate others to their will. So when you talk about co-parenting, it just doesn't make any sense. I mean, it's like the difference between a conventional war and going to nuclear war. It's the difference between dealing with two humans and dealing with one human. And in the literature where they talk about vampires or demons or Satan or evil, whatever you want to call it, you're not dealing with rational human beings who can relate to another human being in a human way. So the idea of co-parenting is just a misnomer.
So when we're not both operating from that same reality, let's call it, what happens in custody cases when one parent cannot tolerate limits, accountability, or disagreement?
Well, yes, and you're dealing with one foot in one universe, which is reality, and that's the one parent, and then you're dealing with another parent who has another foot in this delusional universe that they've self-created, in which they're the perfect parent, they're the perfect spouse, they're the perfect person, they're the perfect everything. And if anyone ever questions their perfection, you'll pay for it because you're not just attacking their behavior, you're attacking their entire identity. You're questioning their reality. And when you do that with anybody, you're you're walking on eggshells. So with a borderline, you're going to If you're in the normal range parent, you're always walking on eggshells. You're always waiting for the other shoe to drop, and you're dealing with a centipede with 100 legs. So there's lots of shoes to drop, and you're just dealing with this ongoing, uh, ingrown, self-sabotaging, destructive pattern. So you can't pretend it doesn't exist. Your choices as the normal parent are to either be a wonderful, good doormat that just is a sycophant who just keeps saying yes, yes, queen, yes, yes, your majesty, yes, everything, or you use the forbidden N word in this borderline universe, which is no. And the minute you use no, because you're trying to protect your children from the devastation and psychological maiming that the borderline is inflicting on the child and the children, at that point you become the enemy and you will pay for it. So, again, the idea of co parenting or getting along in any normal sense of the word, getting along, doesn't really apply in this universe.
So, if one parent is constantly having to give in, I'll say, or agree maybe to something they don't want to, how does that push for co-parenting end up rewarding manipulative or abusive behavior rather than reducing the conflict?
Exactly. That's a great question because what ends up happening is that the court's perception is that the normal range parent who's doing everything he or she can to protect the children is seen as the opposite of what it is. It's seen as like they're gatekeeping or they're trying to engage in parent alienation when they're just trying to get help. And the game that gets played is that the borderlines are exceptionally gifted at turning whatever the normal range parent says in their declarations and in their case into what I call confession projections. So they're going to adopt those accusations that are made against them and then say, no, no, the other parent is the one who's alienating. I'm not alienating. They're the ones who are the gatekeepers. I'm not the gatekeeper. I'm the wonderful, wonderful white witch who does all the wonderful things for these children. I'm not the black witch. And it takes a long time for the courts to figure out who's telling the truth. And that's why at the very inception of every case, it's absolutely essential that the normal range parent sees the moral high ground and paints the right picture and asks for the right sorts of solutions from day one. So we can keep going back and point to that and say, Your Honor, on day one, you remember we said this. And that is what has been the case every single day for the last 5 years that you have not been dealing with the reality of this case, Your Honor. Sorry to say it, Your Honor, but you're not dealing with reality. And so you get into that conundrum of where it's a battle of narratives, if you will, and the borderline is consistently trying to say the other parent is the pathogenic parent when in fact they're the pathogenic parent. And again, this is devastating for the children because as every day, week, month, and year ticks by, the children are just being, as I said, psychologically maimed. They're being destroyed. And the chances after about age 4 or 5 of these children having a normal range adult relationship ever just diminishes substantially.
And then, Clark, when judges encourage cooperation or communication between parents in these cases, what are the unintentional or what are they unintentionally asking the non-borderline parent to absorb or tolerate?
Great question. What they're actually asking them to do is go into a living hell in which they're on the receiving end of mitigated abuse of every level. So it's financial abuse, it's psychological abuse, it's emotional abuse, it's the withholding of the children, it's familial abuse, it's every kind of social abuse, career abuse, reputation abuse. They'll engage in, Sherman's march through the South. Everything is it's just a scorched earth policy, and meanwhile, the children are suffering from that. So again, when the judge says, "Oh, can't you two kiss and make up? Can't you get along? Can't you make decisions jointly? Can't you co-parent? The answer is always unequivocally no. Not because the normal parent doesn't want that. The normal parent would love that to happen, even just one day. But it can never happen because the borderline is not psychologically able to communicate or get along or compromise or settle or do anything then other than be a borderline. So the courts in that case, at the end of the day, are just acting as enablers to the borderline, and they're now tag teaming to see who can abuse the normal range parent the best and the fastest and the worst, and who could be more sadistic towards that parent, the court or the borderline.
At what point does somebody wake up and realize co-parenting is not gonna happen? It's unrealistic, and then it also starts to become dangerous for the children if it hasn't already.
Well, you're right. The truth is that every day that the children spend with a pathogenic parent is a day where they're being imprinted with symptoms that will develop into either borderline personality disorder if it's a same-sex child, or ADHD, anxiety disorders, depression, things like that in the opposite sex child. So when the children are in that situation, every day counts, but courts don't deal with these cases in an emergency fashion. Like, you have all these courts that are dedicated in California now to just hearing nothing more and nothing other than domestic violence restraining order hearings every single day. And when you're dealing with borderline cases, the level and intensity of abuse is 10 times higher than most of the garden variety physical violence cases that they treat with such promptness and such efficiency and such concern. But they don't do that for borderlines because they don't understand psychological abuse and don't want to. By and large, they don't want to. So I'm not sure if that answers your question entirely, but you're just dealing with people setting up these situations, judges having to change their perceptions over time about what the real problem is. And frankly, it's a rare judge that is willing to take the time to actually get to know the parties that well. And the other professionals, by the way, it's not just the courts. I mean, it takes a lot of time to get the psychologist or the child custody evaluator or the court appointed whatever, a guardian ad litem or minors counsel, all these other cooks in the kitchen that are actually contributing to the children's demises. They don't understand going in what they're dealing with, and it takes months and months and hours to present them with evidence and evidence and evidence, oh, day after day, long histories of abuse, where one day they finally go, oh, this really is not a bilateral conflict. It really is a unilateral conflict. And when that day happens, then you get one more person on your team and then one other person on your team, and they finally all go in, and you have now 6 or 7 people that you've paid for that have now cost $1 million to get them educated. And now when they all say, Your Honor, you're looking through the wrong end of the telescope. You need to turn the telescope around and look at this case close up. And then at that point, then the judge usually gets with the program. But the judges are always the last ones to get figure out what's going on, even though they are the place where the buck stops, and they're the ones that have the obligation and the monopoly on deciding the children's future.
And then, Clark, how does the language of co-parenting blur the line between protective parenting and accusations of parental alienation?
Right. Well, so we've just touched on that a little bit, but it's so important. I mean, it's so people just have to understand this that um, again, from the judge's perspective, they're talking to you like you're talking to two normal people. Can't you get along? Can't you solve your own problems? You don't want me imposing what I think your life should look like on you, do you? Oh, can't you communicate on talking parents or family wizard? Can't you make decisions about the children's educations or healthcare or anything? And again, the answer is always no. That's not possible. It's just not possible. And so if they want you to co-parent, that's their perception. But what they're actually doing, what's going on with all these other things, they are actually condemning and sentencing the normal range parent to a life in hell where they have to stand by and watch their children being destroyed. And that's what's going on. I mean, there's no other way to explain it. And so the narratives that are being controlled and all the games that are being played in court are all going to end up destroying the children. And the courts don't understand that they're partners in crime. They just don't get that.
So here's where I want to wrap this up today, Clark, is if co-parenting is not possible in borderline cases, what framework should courts be using instead to protect children and stabilize custody outcomes in these cases?
Okay, so now we're jumping from day one of the process through year 4 or 5 now, and now you finally get to where the court is open to actually entertaining a solution to the problem rather than just kicking the can down the road. And we've talked about this before, this is where you need to essentially in the court, you're going to get an order that gives sole legal custody to the normal range parent. So they just get to make all decisions having to do with legal decision making. Right. What doctors do you go to? Do you do a private school? What religion do you practice? What sports do you get involved in? Do you go to camp this summer? With whom? All those things, all those decisions are made by the decision making authority is given 100% to the normal range parent. That doesn't mean that the other parent is excluded from the process, because once you give the normal range parent 100% control and decision-making authority, and the borderline realizes that the borderline has no power, no control, they can't manipulate, they can't deceive, they can't subjugate anymore, they become somewhat cooperative. It's the most amazing thing you'd ever seen in your life. You couldn't imagine it for the first 5 or 7 or 8 years of the case. Couldn't happen. But as soon as you take all the power away from the borderline, then they become more cooperative, more complacent. And I didn't say complacent, more helpful, more cooperative. So the normal range parents will say, we're trying to make a decision about X, Y, or Z. What are your thoughts? And then the other parent, the borderline, gives their opinion or thoughts, and then a decision is made. That's on the legal level. The court also has to order primary and almost sole custody to the normal range parent. And this includes the right and the power to make deviations from the custody schedule. So let's say you have a custody plan that the judge stamps after hearing all the expert testify that the primary parent, normal range parent, is going to have custody during the school year and for most of the summer. And then the borderline parent will get some holidays, some vacation time, and whatever other time the normal range parent wants to give that parent. Again, because all the power is now with a normal range parent, and normal range parents always want to have the other parent included to the extent that they can be without harming the children, so they can be the protective parent, you're going to see that parent be very generous. And they're going to be giving the other parent as much time as the borderline parent can handle without pathologizing the children. And that's the key. And when the judge arrives at that aha moment where they actually say, wow, the normal range parent is actually handling this. Now after 6 months of this trial, you come back after 6 months, and maybe you even have a psychologist or a guardian ad litem or somebody who's monitoring what the normal range parent is doing, how the children are doing. Are the symptoms of pathology dropping and minimizing, or are they increasing? And if they increase, you take time away from the pathogenic parent, the borderline parent, and you wait for those symptoms to subside, and then you increase them again. But you have to give the authority to the other parent to have that flexibility. And that's what normal range parents do, right? I mean, they're generous, they're flexible, they're thoughtful, they're protective. You have to understand that sometimes borderlines marry people that they think they can manipulate the most or are going to bend over backwards to accommodate their pathology. That normal range parent is also the one that's going to protect the children and include the borderline in the children's lives. So that's the ultimate goal. That's the ultimate order that you're looking for. One that takes the teeth out of the borderline, those vampiric fangs, and you take out the fangs, you remove the power, and then the other parent has the power and the authority and the rights to make the decisions that are best for the child. Period. End of story.
And Clark, we're going to leave it there. Thank you so much for your insights today. That's it for today's episode of Vampire Divorce. If you'd like to learn more about Clarke Young's work as an attorney, a consultant, or an expert witness in high conflict custody cases, visit clarkeyoung.com. Thank you for listening, and don't forget to subscribe, share, and leave a review so this conversation can reach the people who need it most today.
Thanks for having me, Lisa. Good seeing you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.